Welcome to the Deep Dive, where we take your sources and uncover the most important insights.
Today we're doing a deep dive into excerpts from Elie Mystal's book, Bad Law.
And the main idea Missel puts forward is, well, it's pretty striking. He argues that a lot of the really big, complicated problems in America today, they're not just random. He says they actually stem from specific, really bad laws that are still around.
Exactly. And his whole point is you can't actually fix the mess these problems create unless you first get rid of those underlying bad laws.
Yeah.
So our mission today is to really unpack what he's saying about these specific laws, look at the history and the impact he describes in the sources, and, understand why he thinks repeal is step one.
So, get ready. We're going to cover a lot of ground voting rights, immigration, airlines, crime, guns, religious freedom, LGBTQ plus rights, all seen through this lens of how, according to Missel, these laws actively hurt people and keep existing power structures in place. Let's get into it.
Okay, so Missel kicks things off right at the core of democracy, basically asking, why isn't everyone registered to vote?
And his answer is, well, pretty blunt. He says voter registration laws, they're not about stopping fraud. He argues that's not really a thing. He claims they're actually anti-democratic by design. They're meant to stop people from voting.
Yeah, and the history he lays out is really key to his argument. He goes right back to the beginning, points out that voting started with property qualifications. He even brings up John Adams worrying about, wealthy white guys being outnumbered if men without property could vote.
Right. So he's saying it's not an accident, it's a feature. That these laws were deliberately set up from the start to keep a certain group in charge, wealthy white men. And he traces that idea right up to modern stuff, like January 6th.
Precisely. He makes the case that not having a guaranteed right to vote is a, quote, key defining feature of the U.S. system. He basically says America's never had a truly free election because barriers have always been put up by those in power.
Which leads him to his first big proposal for making elections more democratic. Just repeal voter registration laws? Completely, get rid of them.
Right. He also touches on the 1888 election, saying it was sort of the last one before the secret ballot became widespread. We got that from Australia. And he suggests that while the secret ballot aimed to reduce corruption, it might have accidentally made voting feel more individual, maybe harder, and potentially lowered participation compared to, older ways people voted.
And to show this isn't just about, say, southern states, he really digs into New York. A blue state, right?
Right.
But he calls its registration laws like the original gangsta of voter suppression tactics.
Yeah, he explains that historically New York's rules were used by the folks upstate to kind of weaken the political power of immigrants pouring into New York City.
Okay, so the basic rules: 18, citizen, live there 30 days, not a felon in prison, mentally competent, they sound standard. But he points out the catches, like the Motor Voter Act helps, but if you're in NYC, maybe you don't drive, you don't have a license. So it hits renters harder, people who move more often.
Exactly. That 30-day residency thing really impacts people who are mobile. And the fact that there's no real same-day registration is another big hurdle. He even kind of dismisses recent talk about registering during early voting because, well, the deadline is still the same as the old pre-registration deadline.
So Mistel's main point here is pretty stark. Voter registration isn't just paperwork. He's arguing it's an intentional system that keeps certain groups, especially poorer people, people who move around from voting, and that serves an anti-democratic goal.
Okay, so from who gets to vote, we move to who gets to even be in the country. Mistal asks next, how did immigrants become illegal?
And again, he doesn't hold back. He basically calls the entire U.S. immigration system a result of poor, self-defeating choices. And he says it was racist right from the get-go, designed explicitly to keep America white and Protestant.
And he stresses this wasn't some hidden agenda. He says the racist goals were stated pretty openly by lawmakers throughout history.
He really focuses on two specific laws: Section 1325, illegal entry, and Section 1326, illegal reentry. He lays out the scenario. Someone tries to enter legally, gets denied, then tries to cross anyway. He mentions things like Greg Abbott's moat, and boom, the second they cross, they're labeled a criminal, a felon under these laws.
And the consequences are serious. Up to 2 years in prison for the first illegal reentry, up to 10 for a second. And crucially, this often leads to families being torn apart, kids ending up in state custody.
Plus, once you get that felony conviction for illegal reentry, he argues, trying to enter legally later, maybe for a guest worker program or something, becomes almost impossible.
Right. And this is central to his argument on immigration. He says illegal reentry makes status a crime. Just, existing in a place without the right papers. It's not about punishing harmful actions. He calls this wrong and stupid. People should be jailed for hurting others, he says, not just for being somewhere without permission.
And he traces the specific idea, criminalizing status, back to the Undesirable Aliens Act of 1929, also known as Blease's Law.
Yeah, he explains this law was openly racist, specifically aimed at making seasoner Mexican farm workers into criminals once the harvest was over. He includes this really disturbing quote from a eugenicist, Dr. Laughlin, who advised the bill's sponsor, talking about fears of race mixture and needing to protect the purity of women of the upper classes. That was the justification.
Wow, that history really puts his view of the current political debate into perspective. He kind of paints it as Republicans wanting to violently kick out, deport, and jail brown people, often using slurs, while Democrats, he suggests, want to do basically the same thing, just maybe more politely, more orderly.
So the solution he offers is, again, pretty simple on paper. Just repeal sections 1325 and 1326, get rid of them entirely. He mentions the New Way Forward Act as a bill that aims to do that.
He uses the Kate Steinle case, the tragic death and the acquittal of Jose Inez Garcia Zarate, to illustrate this point about criminalizing status. Zarate was undocumented, the gun involved was stolen from a federal agent, and he was found not guilty of the actual killing.
Right. Mystal asks, how is Zarate's immigration status actually relevant to Steinle's death? He suggests a white person finding and accidentally firing that same stolen gun might also have been acquitted. His point is that politicians use cases like this to paint all immigrants as dangerous criminals, when really Zarate's main crime in that context was being in the country after being deported his status.
And his concluding thought on this is pretty direct, something we hear a lot. The U.S. is becoming more diverse, ethnically browner, and you just can't shoot, jail, or deport your way out of that reality.
All right, shifting gears from who's in the country to how we get around. Mystal asks, who gave away the skies to the airlines?
And he pinpoints a very specific date, October 24, 1978, the Airline Deregulation Act. He calls that the moment democratic neoliberalism was born.
He briefly sketches the early days of flying kind of chaotic, right? Small airlines going bust, tickets super expensive, routes were limited, financially unstable.
Which led to the government stepping in, creating the Civil Aeronautics Board, the CAB, in 1938. And he notes they had this idea, sort of like the post office with stamps, where profitable routes would help pay for less popular ones, making sure smaller towns got service too.
But, as happens with regulatory bodies sometimes, he says the CAB eventually got hit with corporate capture. Basically, it started acting more like a cartel, protecting the big airlines' profits instead of looking out for the public.
And that's when this neoliberal thinking started gaining steam, the law and economic stuff, from people like Robert Bork. The idea was that laws should focus purely on market efficiency, getting prices down, not worrying about social goals.
So deregulation was pitched as the way to get more competition and therefore lower fares for everybody.
He names some key figures who pushed this within the Democratic Party. Stephen Breyer, who later ended up on the Supreme Court, Alfred Kahn, Phil Bakes, even Senator Ted Kennedy. Breyer apparently led the Senate hearings and helped write the bill.
And the act just dismantled the CAB's powers. No more price controls, no more route restrictions, made it easier to start an airline, got rid of those mail subsidies that kept smaller routes going. The CAB itself eventually disappeared.
And Mystal makes this really relatable with a story about being stuck on a delayed plane. The pilot maybe fibbing about the time, him wanting to pull up the passenger rights rules, his mom's reaction.
Yeah, he uses that whole frustrating experience to kind of capture the result of deregulation, which he calls a rapacious and dysfunctional industry now.
He argues that 1978 was this huge turning point. Neoliberal ideas took over the Democratic Party, he says, cemented later by Bill Clinton, who actually studied under Bork, which led to Breyer getting on the Supreme Court, and Clinton famously saying in '96, the era of big government is over.
And the result, according to Mystal's take in the book, flying is often awful, the industry acts greedy, and that promise of cheap flights for everyone. Maybe not so much, especially if you're not flying between major hubs.
Okay, from the frustration of flying to the deep injustice of mass incarceration, Mystal asks, why do we lock up so many people?
And he points a really big finger at the 1994 crime bill, especially its push for mandatory minimum sentences. He sees that as a major cause of mass incarceration.
He zooms in on the 15-year federal minimum sentence. He explains it's based on this theory called incapacitation. The idea is you lock up criminals when they're most likely to commit crimes, supposedly between ages 15 and 30.
But, he argues, the way these mandatory minimums often work, especially with three strikes rules, is they end up hitting older people, people who are statistically aging out of crime anyway. So you're over-incarcerating people who might be less of a risk.
And he mentions laws like the Armed Career Criminal Act, ACCA, from '84, and the '94 crime bill used really fuzzy language, especially around what counts as a violent felony. So they ended up catching way more people than maybe intended, not just the most dangerous offenders.
Right. And he notes the Supreme Court even stepped in a case called Johnson v. United States in 2015, saying the ACCA's definition of violent was just too vague, unconstitutional. But the fix wasn't great, he says, because now courts look at state laws, which means the same crime might count towards a mandatory sentence in one state, but not the one next door. It's inconsistent.
What Mystal finds particularly outrageous is how these laws were originally sold. He says both Republicans like Arlen Specter and Democrats like Ted Kennedy pushed the ACCA, claiming it would reduce prison crowding by focusing only on the worst offenders and reduce racial inequality by making sentences mandatory and supposedly equal. He calls these arguments cockamamie and basically political calculation, suggesting they thought more racism provided the shortest path to the White House.
He thinks a huge mistake was taking sentencing discretion away from judges and giving way more power to prosecutors. Prosecutors, he argues, can then apply their own biases across a much wider net.
And he claims mandatory minimums give prosecutors this incredible leverage to force plea bargains. They don't always have to prove their case beyond a reasonable doubt in court. They can just use the threat of a huge mandatory sentence, the fear of God and prison, as he puts it, to pressure defendants into pleading guilty.
Right. And this hits poor defendants and black defendants the hardest, he argues. They often can't afford a good defense or risk going to trial and facing maybe decades if they lose, so they take a plea deal even if they might have a case.
He also brings up the Anti-Drug Abuse Act of 1986, the infamous crack versus powder cocaine disparity, that 100-to-1 ratio. He argues it was bleedingly racist, treating black users of crack like hardened criminals, while white users of powder cocaine were often seen more as addicts needing treatment. He contrasts it with, say, alcohol prohibition, where they didn't generally throw white drinkers in jail with mandatory minimums.
And even recent attempts at reform, like the First Step Act under Trump in 2018, it made the crack sentencing changes retroactive, reduced some minimums. Mystal kind of dismisses it. He compares it to bringing buckets instead of going to the new roof section when your roof has a giant hole. It didn't get rid of mandatory minimums, didn't touch that ACCA 15-year rule.
So his bottom line here is pretty heavy. The ACCA, the 1986 drug law, and especially the 1994 crime bill are major reasons we have mass incarceration. He says they criminalize poverty and are, in his view, the most racist laws passed since segregation ended.
All right, let's shift now to another really contentious area involving laws and violence. Mystal asks, why do we protect arms dealers?
This section obviously tackles gun violence, but specifically the legal protections given to the gun industry. He mentions tragedies like the Aurora shooting to ground the discussion in reality.
And his argument is basically this. Conservative courts have made it really hard to ban guns directly because of how they interpret the Second Amendment. So you can't ban the guns, he says. You have to focus on the industry that makes and sells them.
And the tool he proposes for that is massive tort litigation, lawsuits. He sees trial lawyers, tort lawyers, as the unsung heroes of consumer safety. In other areas, they hold companies accountable when products cause harm. He thinks the same should happen with guns.
But there's a huge roadblock. The Protection of Lawful Commerce in Arms Act of 2005, PLCAA.
Right. He describes this law as giving gun makers and sellers really broad immunity from lawsuits when their guns are used to commit crimes. He flat out calls it one of the worst laws ever passed. He notes the NRA chief, Wayne LaPierre, was thrilled, saying it put the Second Amendment in its best shape.
And he highlights this really strange outcome. If a gun is defective and it hurts you, the owner, you might be able to sue. But if the gun works exactly as intended and someone uses it to kill you during a crime, generally you can't sue the manufacturer or seller. He argues no other industry gets that kind of shield. Car makers still get sued, even if a drunk driver causes a crash, right?
He contrasts this with what happened before PLCAA. The Clinton administration apparently struck a deal with Smith & Wesson, and the company agreed to certain restrictions because they were facing the threat of lawsuits. It showed the industry could be pressured by legal action.
But PLCAA shut that down. He notes some Democrats, like Joe Lieberman, actually voted against it, understanding it would stop that market pressure from lawsuits. He does mention Bernie Sanders voted for it, explaining Sanders felt shop owners shouldn't be responsible if someone buys a gun legally and then flips out.
The Sandy Hook lawsuit, Soto v. Bushmaster Remington, becomes his main case study here. The family sued Remington, whose Bushmaster rifle was used in the massacre.
Initially, the lawsuit got tossed out because of PLCAA, but the Connecticut Supreme Court eventually let it go forward, but only on a very narrow legal theory that Bushmaster's marketing might have violated a specific Connecticut Consumer Protection Law, CUTPA, and that marketing contributed to the tragedy.
Remington ended up settling for $73 million. But Mystal is really dismissive of this. He calls the amount pathetic compared to what the Smith & Wesson deal might have achieved. He argues the settlement didn't force any changes in industry practices and was mostly just PR. He claims industry experts agree it didn't really weaken PLCAA, and Remington probably figured they'd win if it went all the way to the Supreme Court anyway. So the takeaway from Mystal is clear. PLCAA is a terrible law because it shields the gun industry from the normal market consequences accountability through lawsuits that apply to other industries.
Okay, and building on that, Mystal includes a short but pretty pointed interlude. He asks, why is the Second Amendment so violent and stupid?
Right. He basically links the Second Amendment to a lot of the bad laws he's already discussed, like felony murder, mandatory minimums, stand your ground, because in his view, the easy availability of guns is what makes so many encounters turn deadly when they might not otherwise.
And here, he really takes aim at the dominant conservative legal interpretation, especially Justice Scalia's opinion in the Heller case, which found an individual right to own guns for self-defense. Mystal just thinks that interpretation is historically and legally wrong.
So what's the solution, according to him? He actually echoes what retired Justice John Paul Stevens suggested. Repeal the Second Amendment. Get rid of it through a constitutional amendment. He notes Stevens saw Heller as wrongly decided and felt the Second Amendment had become this powerful propaganda weapon for the NRA.
Mystal argues that the Second Amendment, as interpreted now by conservative courts, is the main reason we can't pass popular gun safety laws, things like universal background checks, waiting periods, red flag laws, and it's used to justify selling weapons like AR-15s.
He mocks the conservative legal approach a bit, saying they basically argue any gun law that didn't exist in 1787 is probably unconstitutional, which he finds ridiculous given how weapons have changed.
So his conclusion in this interlude is that the Second Amendment isn't just legally problematic. It's dangerous as a marketing tool that stifles real debate and prevents meaningful action on gun violence. Okay, let's swing back to the justice system for a moment with another really challenging question Mystal poses. How can you murder someone if you didn't kill anybody?
Yeah, this is where he tackles the felony murder rule. And the definition itself is, well, kind of mind-bending. It means you can be convicted of murder if someone dies while you're committing another felony, even if you didn't pull the trigger, didn't intend for anyone to die, didn't even know someone died.
Right. He points out he gets rid of the usual requirements for murder, like proving malice aforethought or premeditation. And he notes we already have other laws, like manslaughter or reckless homicide, to cover situations where someone is killed unintentionally.
Mystal offers his own guess about why this rule sticks around, and it's a pretty damning one. He thinks it helps police avoid accountability when they kill people.
How? Well, he describes situations where police respond to a crime in progress, and someone ends up dead, maybe an accomplice, maybe an innocent bystander, maybe even the person trying to run away. Under felony murder, the surviving people involved in the original crime can be charged with the death, not the officers who actually did the killing.
He says it can even apply if the initial crime was something like trying to escape police or resisting arrest.
The case he uses to make this incredibly clear is Breonna Taylor. Police killed Taylor during a botched raid. Her boyfriend, Kenneth Walker, fired a shot thinking they were intruders, and he was charged with assault and attempted murder of an officer.
But here's the crucial part Mystal highlights. Walker was not charged with Taylor's murder, and the reason. Kentucky, along with Hawaii, got rid of its felony murder law way back in 1975.
Mystal argues that if this had happened in almost any of the other 48 states that do have felony murder rules, Walker almost certainly would have been charged with Taylor's death because it happened during the alleged commission of his felony, assault, attempted murder, resisting, etc.
He mentions the Supreme Court has tried to put some limits on it, like in a 1982 case, Enman v. Florida, saying you couldn't get the death penalty under felony murder if you only played a minor role. But he also notes Justice White dissented, wanting it applied even more broadly.
He calls out Pennsylvania's version of the law, which they call second-degree murder, as being particularly harsh. It carries a mandatory life sentence without parole, even without the death penalty option.
And the racial disparity he points to is staggering. In Pennsylvania, he says 70% of people serving time for felony murder are black, 80% are people of color overall, in a state that's only about 12% black.
He connects this disparity directly to racism, the idea that white people are often seen as individuals who make mistakes, while black people are viewed through harmful stereotypes, which influences how prosecutors charge cases.
So his verdict on felony murder is scathing. It's unjust, it's draconian, it disproportionately hammers young black defendants, and importantly, it functions as a shield for police accountability in killings related to suspected crimes.
Okay, building on that theme of violence, race, and legal justification, the next section asks, why do we give white guys a license to kill black people?
This is where he gets into castle doctrine and, even more pointedly, stand your ground laws. He defines castle doctrine first. It lets you use deadly force against someone unlawfully entering your home or business, even if you aren't actually in immediate life-threatening danger. The justification shifts, he says, from self-preservation to property rights.
Mystal argues this is kind of unnecessary because regular self-defense laws already cover you if someone breaks in and genuinely threatens your life.
And he makes the point that, practically speaking, people who shoot armed intruders inside their homes are very rarely charged anyway. He gives the example of Nancy Pelosi's husband fighting off his attacker clearly justified self-defense under existing law.
He brings up recent high-profile cases. Kevin Monahan in New York, who shot a young woman who accidentally drove up his driveway. He was convicted. And Andrew Lester in Missouri, who shot Ralph Yarl, the black teenager who rang the wrong doorbell, awaiting trial. Mystal doubts either shooting meets a reasonable standard for deadly force, even with castle doctrine.
He expresses some hope for the Yarl case because of the public attention and the fact that Ralph survived to testify. But his bigger point is about a culture where, he argues, some white men feel legally and morally entitled to shoot perceived trespassers who aren't a real threat, treating them like vermin fueled by media narratives.
Then he shifts to stand your ground laws. He sees these as taking the castle doctrine idea, no duty to retreat from your home, and applying it everywhere you have a legal right to be. He calls these laws violent, racist, and unnecessary. He claims they're based on a Republican and NRA fabrication, a made-up need for more self-defense rights than people already have.
He focuses on Florida's law, the first stand your ground law, as the prime example, emphasizing how it explicitly removes the duty to retreat.
And here, he uses a specific Florida case from 2004, James Workman, to challenge the whole premise of the law. Workman shot and killed an unarmed FEMA contractor who came into his trailer looking for shelter during a hurricane.
Mystal argues that killing the man inside the trailer was already justified self-defense under standard law. Not a close case, he says, and Workman was never charged. But, Mystal claims, stand your ground was passed unanimously in Florida based on the false narrative that people like Workman needed this extra immunity, which they didn't. So the law was passed on a faulty premise, he argues, and then it extended that no-retreat logic outside the home. He even notes the lawmaker who pushed the bill later couldn't even remember the Workman case that was supposedly the justification.
And he absolutely highlights the racial bias. He cites studies, including those looking at the aftermath of the Trayvon Martin killing, showing that stand-your-ground defenses are far more likely to succeed for white shooters than for black shooters in similar situations.
So his conclusion: stand your ground is violent, racist, unnecessary, gives white men a pass for killing, and was built on a lie pushed by the NRA and conservative politicians.
All right, moving from physical violence to battles over bodily autonomy and personal choices. Mystal asks, how do they fit the federal budget inside people's wombs?
This section is clearly about abortion restrictions, which he argues are driven by what he calls the Republican caricature of Jesus H. Christ.
And his main argument here is that the abortion debate isn't really about morality or individual choice. He says it's fundamentally about government power. He's quite critical of Democrats, saying they got stuck talking about choice bullshit instead of fighting the power grab by his term Christo-fascists.
He lays out what he sees as the hypocrisy of the anti-abortion stance. They claim horror over late-term abortions, but then work to restrict access so early and severely, and especially block insurance coverage through things like the Hyde Amendment, that people are forced into later, more complex situations. Then they demand birth, but simultaneously try to gut social programs that would help support those children and families.
He mentions the global gag rule as the U.S. basically exporting this forced birtherism, as he calls it, internationally.
He contrasts the rationales. Republicans say it's religious belief. God likes babies. Democrats, he says, citing Joe Biden's past stance, sometimes argued it's not fair to ask taxpayers to pay for something they religiously object to.
Mystal finds this unique and absurd in American law, the government being actively prevented from helping citizens access something that is perfectly legal. He thinks the Hyde Amendment, which blocks federal funding, like Medicaid for most abortions, is flat out unconstitutional.
He uses the 1980 Supreme Court case McRae v. Califano to show Hyde's impact. It was a challenge brought by Medicaid recipients who were denied medically necessary abortions.
He tells the story of Cora McRae, one of the plaintiffs.
Yeah.
She needed an abortion for health reasons, but doctors couldn't say with absolute certainty she would die without it, so she didn't qualify for the very narrow life of the mother exception under Hyde.
The Supreme Court sided with Hyde. They ruled the government wasn't violating the Constitution by simply choosing not to fund abortions. They weren't stopping anyone, just not paying for it.
Mystal floats a possible strategy for a future pro-choice administration. Find ways to fund related things, like travel expenses for people who have to cross state lines to get legal abortions.
He predicts the current conservative Supreme Court would try to stop that, maybe inventing something he sarcastically calls a fugitive uterus act, perhaps even referencing the infamous Dred Scott decision. But he argues the administration should do it anyway. Force the court to make an unpopular, potentially misogynistic ruling, and then use that to build public support for repealing Hyde and maybe even reforming the court itself. So his final point here. Laws restricting abortion access, Hyde especially, are religiously driven, incredibly harmful, hit poor women the hardest, and show a government deliberately failing to help people exercise a legal right.
Okay, from abortion access to freedom of speech and identity, particularly in schools, Mystal asks, why can't we say gay?
Yeah, this is about laws like Florida's Don't Say Gay bill, officially the Parental Rights and Education Act. Mystal's take is pretty straightforward. He says the root issue is bigotry. It's people being angry about LGBTQ plus folks being treated as normal. He argues they have no problem with talking about gender or relationships if it's strictly heterosexual. You know, daddy said mommy looks pretty.
And he points out the way these laws are enforced is really insidious. They empower parents to sue teachers and school districts, putting the financial burden on educators. Teachers and librarians become really vulnerable targets.
This ties right into book banning efforts, right? Where it's easy for parents, often organized groups like Moms for Liberty, he mentions, to challenge books, and then the job of defending free speech falls on teachers who are already overworked and underpaid, or sometimes even on students themselves. He references the Pico case, where students fought book removals. Mystal gets pretty fiery about the whole parental rights framing. He argues knowing your kids is a privilege you earn, not a right to keep them ignorant or unhealthy by blocking education about science like evolution or geology or about vaccines. He suggests homeschooling is the place for parents who want to reject reality-based learning. He contrasts this with his own choice not to homeschool, even though he has concerns about systemic racism in schools.
He dismisses the settlement reached in Florida in March 2024, which supposedly clarified the law doesn't discriminate, as just a PR stunt. He says it doesn't change the reality on the ground. Books are still gone, parents can still sue, and schools are still pushing gender conformity.
And spreading. He notes when the book was written, at least 20 other states were considering similar laws, and 7 had already passed them. He mentions Representative Mike Johnson proposing a national version, the Stop the Sexualization of Children Act. Mystal warns its language is so vague it could potentially ban even basic school activities like separating kids by gender for gym class. So his conclusion is harsh. These laws aren't about parents, they're legislative terrorism. They write bigotry into law, target LGBTQ plus people, stifle free expression, and follow a long history of conservative backlash against reality and equality in education.
And this leads naturally into his final major topic, looking at the broader role of religion in U.S. law. The question, who died and put God in charge of our laws?
Right. He examines how religion, specifically through the First Amendment's free exercise clause, shapes our laws. He starts with a provocative take on the First Amendment itself, arguing it was basically a truce between different groups of Christian extremists, Puritans, Anglicans, etc., so they could get on with the business of taking land and enslaving people, using their faith to justify it all.
The ideal of the First Amendment, he acknowledges, is a secular government, one that protects people's right to practice their religion, but stops any single religion from forcing its views on everyone else through law.
But the reality, he argues, is that the other part, the Establishment Clause, no government establishment of religion, has never really been enforced properly. He says Judeo-Christian, particularly white Anglo-Saxon Protestant, values have always been baked into American law.
He argues the current situation, where claims of free exercise are rampaging, really kicked into high gear with the Religious Freedom Restoration Act, or RFRA, passed in 1993. Okay, so RFRA. He explains it essentially put back in place a very high legal standard called strict scrutiny whenever a law significantly burdens someone's religious practice. It means the government needs a really compelling reason for the law and must prove it's using the least restrictive way possible to achieve its goal if it limits religious freedom.
And the context for RFRA is important. It was a direct response to a 1990 Supreme Court case, Employment Division v. Smith. In that case, Justice Scalia wrote the opinion saying Native Americans couldn't use religious freedom as an exception to use peyote because it violated a general drug law that applied to everyone. Scalia actually warned that allowing religious exceptions to every general law would lead to chaos, people claiming exemptions from taxes, military service, vaccinations.
So RFRA passed with huge bipartisan support. Schumer, Kennedy, Clinton were all for it. The stated goal was noble: protect minority religions from laws that might unintentionally burden them because they were written with Christian norms in mind.
But here's Mystal's crucial argument. RFRA got completely turned on its head. It was co-opted, he says, by the very Christian fundamentalist majority it was supposed to protect minorities from.
Instead of being a shield for the oppressed, he argues, it became a weapon for oppressors. He claims most RFRA cases won today are brought by conservative Christians who argue that things like non-discrimination laws or healthcare mandates violate their religious freedom, what he calls a curdled version of their faith.
He points to charitable choice initiatives, government funding flowing to faith-based organizations to provide social services. He says these groups then use RFRA to argue they have a right to deny services, like adoption placements or housing assistance, to people they disapprove of, particularly women and LGBTQ+ individuals, based on their religious beliefs.
He's particularly scathing about Christian antipathy toward the LGBTQ community, calling it frankly unhinged, and saying they constantly push for more legal room to discriminate.
The big case example he uses is Hobby Lobby from 2014. This was a big, for-profit craft store chain owned by a very devout Christian family. They objected to the Affordable Care Act's requirement that their employee health insurance plan cover certain types of contraception.
Now, the ACA already had exemptions for religious nonprofits, like churches, but Hobby Lobby was a business. They sued anyway, using RFRA, claiming that providing that coverage violated the owner's religious freedom by making them complicit in something they believed was sinful.
And the Supreme Court, in a 5-4 decision driven by its conservative Christian justices, agreed. They said RFRA did require an exemption for Hobby Lobby. The result: a company could deny contraception coverage to potentially 13,000 employees because the owners felt it offended their God.
He mentions there's a proposed law called the Do No Harm Act that tries to fix this, basically saying RFRA can't be used to override non-discrimination protections or other fundamental rights.
But Mystal is pessimistic. He predicts the current Supreme Court would just strike down the Do No Harm Act. Why? Because using their originalist logic, they'd say the founders in 1787 didn't explicitly support things like non-discrimination laws, universal health care, or child labor laws, so there's no historical basis to limit religious freedom in favor of those modern concepts.
So his final word on this is that RFRA, originally intended to protect minorities, has been twisted by the Christian majority into a tool for discrimination, letting religious objections override basic rights, especially for women and LGBTQ+ people. So wrapping it all up, Mystal circles back. He says, look, all these laws we've talked about, they're terrible, and it's a mix of reasons: Republicans pushing bad policy, neoliberals enabling it, deep-rooted racism, and sometimes just plain stupidity.
But he digs deeper, identifying what he sees as the fundamental problem. We, the people, don't really get a full say in the laws that govern us. Part of that is historical exclusion, racism, sexism, barriers for poor people. But part of it is structural, baked into how the government is set up.
And one big structural issue he points to is representation. He argues the U.S. just doesn't have enough representatives in the House.
Yeah, he makes this striking comparison. The U.S. House has 435 members for about 330 million people. That's roughly 760,000 people per representative. He compares that to China's National People's Congress, almost 3,000 members for 1.4 billion people, which works out to about 474,000 per rep. So American representatives have far more constituents.
And he blames a specific law, the Permanent Apportionment Act of 1929. That's what capped the House size at 435. He points out it took effect in 1932, and they actually ignored the 1920 census results and used 1930 numbers with the cap already in place. He calls it another bad law that should be repealed, suggesting it was likely driven by racist motives given the time period before the Voting Rights Act.
So his fix, just make the House bigger. He mentions the Wyoming rule as one idea, basically. Set the number of constituents per representative based on the population of the smallest state, which would give Wyoming its constitutionally required one rep. That would mean closer to 580,000 people per rep. Still large, but better.
Then there's the Senate. He doesn't mince words. It's explicitly anti-democratic. 2 senators per state, no matter the population. He traces this back to demands from slave states. He gives power to land area, not people. He uses the example of tiny Rhode Island having the same Senate power as the massive population of Texas, or more power than huge cities like San Antonio. His solution: abolish the Senate.
Wow, okay. And gerrymandering, he sees that as a huge problem too, though he notes it's technically allowed by the Constitution, not created by a specific bad law. He thinks it should violate the 14th and 15th Amendments, equal protection, voting rights. But the Supreme Court basically washed its hands of it in the Rucho case in 2019, calling political gerrymandering non-justiciable, meaning federal courts won't intervene. So facing all these huge systemic problems, what does he tell the listener to do? It actually comes down to something pretty basic. But especially he stresses in midterms and off-year elections.
Right. His point is that high turnout, even in districts drawn to be safe for one party, can shake things up. It can mess with the politicians' assumptions, make incumbents nervous, maybe even change how they vote or who runs in the future. It's about putting the fear of God into one of these Republicans, as he puts it. But the principle applies broadly.
And underlying all of that is knowledge. He argues that understanding why these laws are bad, their history, their impact, that's the essential first step. You have to know what you're fighting against before you can effectively organize to change it or repeal it. Wow. Okay, that was a lot. A real deep dive into so many different parts of American law and society, all viewed through this very critical lens of laws being intentionally bad and harmful.
Yeah, from voting and immigration, things we debate constantly, to maybe less obvious things like airline deregulation, and then the really heavy stuff, mass incarceration, felony murder, gun industry immunity, how religion gets used in law, attacks on LGBTQ+ rights. Quite a sweep.
And the core argument running through it all is pretty stark, that these aren't just outdated laws or unfortunate side effects. Mystal argues many were designed with bad intent, often racist intent, and they continue to function that way, propping up certain power structures and disproportionately harming Black people and other marginalized communities.
Exactly. And the solutions he proposes are often, well, refreshingly simple in a way. Not complicated policy fixes, but just repeal. Get rid of the bad law. And then, tackle those bigger structural things like representation and the Senate.
It definitely makes you connect the dots differently, doesn't it? Seeing that direct line he draws between a law passed maybe 50 or 100 years ago, or even longer, and the real-world problems people are dealing with right now.
Absolutely. It forces you to think about the foundations. So, for you listening, what stood out most from this look at bad law? Was there a specific law or maybe a historical link he made that kind of hit you in a new way?
It's definitely a lot to chew on. Thinking about how much of our current reality might be shaped not just by culture or economics, but by these specific, arguably terrible legislative choices.
It certainly provides a framework for thinking about reform, that maybe sometimes the answer isn't tweaking the edges, but removing the foundation of the problem itself.
A powerful and challenging perspective.
Indeed.
Thanks for joining us. Subscribe for more bookish adventures and hit that like button if you enjoyed the ride.
Don't forget to share the knowledge, spread the word.